Hey guys, today I'm going to talk about the doctrine of res ipsa loquitur, which is a Latin word for the facts speak for themselves. A plaintiff can rely on this doctrine, res ipsa loquitur, and it is the only time that a plaintiff does not have to prove exactly what act or what omission set in train the events that led to the accident. The reason is because the accident was obviously due to the negligence of the defendant. The defendant is the person getting sued. Now, one very good example is a high court case that I'm currently on, where a glass door in a car park collapsed on a woman and she was injured. She got broken bones, she had psychological injuries and whatever. So she relied on this doctrine of res ipsa loquitur when she sued the defendants. This is because when the glass door in a building collapses on someone, it is obviously due to the negligence of the building management. So there's no need to prove exactly what the building management or the managing agent did or did not do that was negligent. Where the thing that causes the accident is shown to be under the management of the defendant or his employees, and the accident is such that in the ordinary course of things, it does not happen if those who have the management use proper care. Then, if the defendant cannot explain the cause of the accident, there is reasonable evidence that the accident arose from a lack of care. The doctrine res ipsa loquitur applies only where the causes of the accident are unknown, but the inference of negligence is clear from the nature of the accident. If the causes of the accident are sufficiently known, then the case no longer becomes one where the facts speak for themselves, and the court then has to determine whether or not the defendant was negligent based on the known facts. A very important requirement for the doctrine of res ipsa loquitur to apply is control. Now, for the doctrine to apply, the defendant must be in control of the thing that causes the accident. It is not always necessary that the defendant be in complete control of all the circumstances, provided that the happening of the accident is evidence of negligence on the part of the defendant or someone for whom he is responsible. If the thing that causes the accident is in the control of one of several employees of the same employer, and the plaintiff cannot point to the particular employee who is in control, the rule may still be invoked so as to make the employer vicariously liable. Let's go through some scenarios to explain this concept of control. If I go to a restaurant and a ceiling lamp falls on my head and crushes my skull, and I rely on the doctrine of res ipsa loquitur, who is in control of the restaurant? Obviously, it's the restaurant owner, the company who is in charge, who owns the restaurant. So, the restaurant owner will be liable under this doctrine. Another example of control can be used from the English case of Cassidy and Ministry of Health. Now, in that case, the plaintiff was a patient at a hospital run by the Ministry of Health. Due to the negligence of one of the doctors in a team of doctors and surgical theatre staff, the surgery caused his fingers to become stiff, okay? The patient then sued the hospital for negligence on the basis of vicarious liability. You can watch my video on vicarious liability. Vicarious liability simply means that if an employee does something bad or negligent, the employer is liable. The hospital argued that the doctor responsible for the negligence was not one of the employees, because the hospital claimed that it had no control over how he performed his job, how he did the surgery. The English Court of Appeal dismissed that argument and held that the hospital was vicariously liable. The Court of Appeal stated that doctors were appointed by the hospital by the defendant, the Ministry of Health, and not chosen by the patient, and therefore the doctors were fully integrated into the hospital. When a plaintiff successfully invokes the doctrine of res ipsa loquitur, he establishes a prima facie case against the defendant. So this is the plaintiff, this is the defendant. Once he successfully invokes this doctrine, it is the defendant's job to displace the effect of the doctrine by providing evidence that he is not negligent. If the defendant produces no evidence that he was not negligent, then there is nothing to rebut the inference of negligence, and the plaintiff would have proven his case. If the defendant does indeed provide some kind of evidence to show that he was not negligent, then that evidence needs to be evaluated by the court to see whether the defendant was indeed negligent. So thanks for watching this video on res ipsa loquitur.